My Lords, I've been told to go over the top on this one.
Delegated.
Delegated. My Lords, may I just touch upon timetable with your Lordships? And of course, this is going to impinge upon your Lordship's time, and if that doesn't work, then we'll think again. If we could finish today at 4:45, if we could start tomorrow at 10 a.m. again, and my learned friend has agreed that they will finish at 3:45 tomorrow, and thereafter whatever replies are required will take place, but of course not going beyond 4:45. I appreciate that that's an impingement on your Lordship's time, but
yes. Yeah. Yes. All right.
thank you.
Well, we're
Lords.
not pleased, but you will come 4:45 tomorrow. That's it.
Understood.
Far down.
Understood, and it may be that we're shorter than that.
We've got everything in writing.
Absolutely, and we're talking about replies.
Okay.
Thank you.
Right.
My Lord, my final 20 minutes. Can I just make two final points on Blot?
Yeah.
The first is we saw in Howco, and this is just to pick up the point that my Lord Justice Zacaroli made to me before the short adjournment.
Yeah.
If the discretion exists, and discretion does exist, it exists even if 100% of all those parties to the compromise or arrangement have voted in favour. And the court may still, in assessing the factors in play and assigning them due weight, refuse to sanction, even if everyone is in favour. The question was asked this morning, well, what about if the creditors abjure the court altogether and agree an out-of-court restructuring? And we say with respect that's a false analogy. Hypothetically, of course, the parties might in another world have agreed an entirely consensual restructuring, but it can't inform the proper exercise of the discretion in this case, where the finding of fact is that the relevant alternative is not a consensual restructuring, but a special administration. This isn't a consensual plan. It's a process in which we say the relevant alternative is a process whereby public interest objectives would ultimately trump creditor interests. That's the relevant alternative, and that informs the discretion, not another alternative where the creditors may have agreed a fully consensual plan. The other point on Blot is that we say that you can look at the relevant alternative in Blot and in the context of assessing impact on third parties, because of course in order to understand what the impact on third parties might be, one necessarily has to make the comparison again between this plan and the relevant alternative being special administration. That's all I was proposing to say on Blot. Can I briefly give you my headline points under my fourth heading? And as my Lord says, you've been addressed fully in writing on this, I'll take this briefly. In the judgment, it might just be worth having the judgment of these statements so my Lords understand what we're addressing. It's at page 236. Under the heading Destination of the Finance. 236, page 236 is the heading Destination of the Finance, and the first paragraph records my submission, which effectively is the steep price of it. That it says RP2, I think it should say RP1 there. Is the steep price worth it?
Yeah.
And the judge identifies in 296 the point of principle as being what degree of assurance should the court require from the plan company to exercise its discretion. And in answering that, Mr. Justice Leech then referred to the Steinhoff decision. That's a bit of a Russian dole authority in that Mr. Justice Adam Johnson refers in turn to Sir Alison Norris's convening judgment in that case, who then refers in turn to the New Look and Pizza Express cases. Now at 297, the judge says he adopts the same approach, which is effectively it's sufficient for the matter to be just more than fanciful. And then he says, if not, and I stress those words, if not, then it's still right to give the plan company an opportunity to put the pieces of the jigsaw on the table. Now, just starting with the jigsaw issue, just the headline points are these. It's an analogy in Steinhoff, as the judge reports in 296, But by the time one gets to 306 of the judgment under appeal, it's become a form of legal test. The final piece of the jigsaw puzzle is standing for RP2 rather than being compared with RP2. And we respectfully submit one needs to be careful with this analogy or metaphor, whatever it is. It's not the test, and it may confuse. But it's not obvious to us that the judge was using the analogy in the same way as it was used in Steinhoff. And it certainly can't be right that the if not can't be right, that the issue in the future can be fanciful, but the court still will act on the basis of some form of jigsaw principle. Now, as to whether the threshold is merely more than fanciful, we say for the reasons given in the argument that neither Pizza Express nor New Look support that approach, and we respectfully endorse the approach taken by Mr. Justice Trower in several decisions which are also referred to by the judge, which is that the degree of persuasion required will depend on what's being asked of the court and the circumstances in which the sanction is being asked of the court. So of course it may be on relevant facts that a more fanciful threshold is sufficient, but that takes me back to the submission that I made as recorded at paragraph 295 of the judgment. Is the steep price worth it? If this was cheap bridge finance or competitive bridge finance, then perhaps the court would be prepared to should have been prepared to accept that threshold. But we say that's not this case. In this case, we say, and the judge found below, that the costs are egregiously high, and in those circumstances, we say the court should have required a greater degree of assurance that those costs would be worth it. So, my lord, that's my fourth point. Can I finally deal with some sweep-up points? So firstly, the judge placed some weight below on Ofwat's non-opposition to the plan, and on appeal, the plan company says that should be given considerable weight. That's the plan company's skeleton at paragraph 69 and 93 to 95. And we addressed that at paragraphs 30 to 38 of my skeleton. The short point is that the court on sanction has to assess the relevant matters for itself. And it can't, we say, place weight simply on the fact of non-opposition by the regulator. And we saw that earlier in the case that I took my lords to this morning in the Walter Jacob case. The court will always consider and test the submissions or non-submissions of a party, whether they're the Secretary of State or we say a regulator, in the same way as other submissions. And we don't need to go there, but we do rely on the approach taken by Mr. Justice Miles in the first Amigo decision as well, where the FCA did oppose, and it wasn't the fact of opposition by the FCA that led to the sanction being refused. The objections were considered on their merits, just as any other opposing party's objections would be considered on the merits, and were considered and were found in that case to be sufficient to warrant sanction not being given. Now, in this case, we say in circumstances where Ofwat doesn't support the plan, but simply doesn't oppose it, nor did it oppose the Class B plan, and hasn't made submissions to the court but confined itself to certain comments and correspondence, that limited weight can be placed on Ofwat's position. And that's not to diminish Ofwat's role as the regulator. We say that's just a consequence of Ofwat not choosing to appear in these proceedings, either below or on this appeal. So, my lords, that's the Ofwat point, and I make a similar point about the pension trustees. I won't develop that. Secondly, on the burden of proof, as my lords will have seen from our skeleton argument and grounds, we say that the judge did misdirect himself throughout the judgment by giving the benefit of the doubt to the plan company at all stages, and so effectively reversing the burden of proof. And there are numerous examples, and we give references in the skeleton argument to where we say the judge effectively said, well, on this I'm going to have to trust what the plan company is telling me. And just to give one example of where we say that if it wasn't corrected on appeal, it might lead to unfortunate practices developing in future schemes and plans. We look in the core bundle at page 231.
231.
Page 231.
Yep.
Sub 4, the judge records my submission. This is in the context of releases. about full and frank disclosure, and the judge rejects that by saying the relevant material was all in the plan documents or in the evidence, even if the plan company didn't draw it to my attention. And we say that at the very least requires some correction. It can't be right that the duty of utmost candour, which has been developed in the cases, most particularly by Mr. Justice Snowden as he then was, can be satisfied by saying, well, it's in the bundle. We don't need to draw it to the court's attention. And we've cited in our skeleton argument some cases which we say could apply by analogy from a different form of full and frank disclosure in the context of ex parte applications. Thirdly,
But that's not a burden of proof point. That's a completely different point. That's a point about full and frank disclosure. I mean, you're absolutely right that in the context of the duty of full and frank disclosure, for example, in the context of interlocutory applications, it's no answer to say, well, it was all in the bundle, and the judge should have read the bundle, because it's incumbent on the parties to draw the attention of the judge to the critical points. But non constat, if it's a contested hearing between parties, particularly this sort of case, which was brought up in a rush, that seems to me to be a perfectly valid point.
well,
If the judge is told, well, it's all there,
yes,
and nobody has said on as it were on your side of the fence, nobody on the appellant side of the fence has said, oh, well, you didn't draw the judge's attention to the following 46 points.
well, my lord, yes. Again, this is the problem with taking this at pace. In the Indic Cat case,
It's simply not a point about is it?
well, my lord, let me just give the reference and I'll move on. It's
Yeah.
paragraph 40 of the Indic Cat case. It's authorities tab 57, page.
Sorry, which case?
I won't ask my lords to turn it up because I'm conscious of trying to
Right.
keep to my guillotine.
Right.
But
Okay.
in that case, there's a paragraph 40 of Mr. Justice Stone's judgment. He does run these 2 points together. He says the burden is on the company seeking sanction,
Yeah, sure.
and as part of that, there is a duty of utmost candour, which applies whether or not there are opposing parties at the hearing.
Not understood.
So they are related. At the very least, they're related points, and we say the judge erred on that. Thirdly, on the costs of the plan. Now, the judge heard cross-examination of Mr. Cochrane, who was the Thames Water CFO, and he accepted the evidence arising from that cross-examination, that the plan company seeks to reopen those findings, and I've addressed that in the aid memoir that we provided to the court. We say the plan company hasn't explained how the judge was plainly wrong, in the sense that no reasonable judge could have accepted the evidence arising from the cross-examination of the CFOs. So I'll see how my learned friend seeks to relitigate the evidence, and I'll respond as necessary. But we say simply asserting the judge was wrong on the costs isn't enough. Fourth sweep-up point, on the length of special administration. The judge importantly found, and this is in the judgment at paragraph 293, may just be worth going there briefly. It's on page 235.
Yeah.
That he saw no reason why a special administrator could not take over the equity raise and complete it in much the same time as the plan company. This, in fact, I think ties in one of the points that my Lord the Chancellor put to my learned friend Mr. Thornton this morning. Again, the plan company seeks to challenge that finding. It's worth noting that this was in fact the expert evidence of Mr. Hayes, or Hess, I'm probably mispronouncing his name. Heiss, I'm sorry. Heiss, if we could go just briefly to the supplemental bundle, it's at tab 16. Page 629. Paragraph 2.2.8. The evidence is given that the equity raise process could be continued, which would lead to a special administration of 7 to 8 months. Now that expert evidence wasn't challenged by the plan company in cross-examination, so it wasn't open to them to run this case in closing on at the sanction hearing, and we say it's not open to them to challenge the conclusion the judge reached on this appeal for the same reason. It's also just worth noting that I put this point to both Mr. Fraser, Mr. Cochrane and Mr. Burleson in cross-examination. Finally then, my lords, on the costs of special administration, it's worth again just looking at the judgment, page 235. At paragraph 291, Mr. Cowlishaw's evidence is set out in the first sentence, and then it's recorded that that was based on a number of assumptions that were challenged in cross-examination, dealt with the length already. And then there's a reference to overlays, and then the government cost of findings. And then at 292, there's a finding that as a result of the cross-examination, the judge concluded that those assumptions and forecasts were very pessimistic, including because they were based on the assumptions which an insolvency practitioner would make on a normal administration rather than special administration. And there's the double counting point as well. Now, the point that we make in the skeleton argument, I'm not going to develop it, but if one lines up the findings that the judge makes about the costs of the plan, which I've already addressed, against the judge's findings about Mr. Cowlishaw's evidence, we say the costs of special administration are cheaper. We give the details of paragraphs 43 to 47 of my skeleton argument, and we've given the cross-references through to Mr. Cowlishaw's report, where he identifies the additional overlays, monthly overlays of special administration. And we say with respect that the calculations are straightforward once one lines up the findings of the costs of the plan, costs of special administration, and bearing in mind the judge's finding that special administration was unlikely to be much longer than the timeline envisaged under the plan. Now, my learned friend Mr. Smith challenges that. I'll see how he develops that attack, and time permitting, I will deal with that in reply, but I just wanted to outline what our case was on that now. Subject to any other points where I can assist the court, those are my submissions.
Thank you, Mr. Lee. Yes, Mr. Smith.
Thank you very much, my lord. As your lordships know, we say these appeals are without merit and should be dismissed. At the outset, we'd invite the court to focus on exactly why it is being said that the plan is unfair. As we understand it, it's the unfairness that is said to lie at the heart of these appeals. My lords, as you know, the plan is an interim plan. It will act as a bridge to a second restructuring plan, which will affect a substantive restructuring of the debt and the equity. And for these purposes, it does essentially two things. Firstly, it introduces the new super senior funding, and secondly, it extends the maturity of the debt by 2 years. Now, as we understand it, neither the Class B AHG nor the subordinated creditor say that either of those things are themselves unfair in principle or unfair in concept. Indeed, my friend Mr. Thornton this morning said they don't complain about the introduction of the super senior debt, which is perfectly sensible. And by that, I mean, I understand him to mean the concept of introducing the new super senior debt in this plan. And indeed, as the judge pointed out, the Class B AHG and the subordinated creditor would also be subject to the introduction of more super senior funding in a SAR, which they now accept is the relevant alternative to the plan. They also accept now that they're no worse off under this plan than they would be in the relevant alternative of a SAR. And, my lord, it is the case that there will be a second restructuring plan, and it's in the context of that plan that any permanent restructuring of the debt and equity will take place, and that will take place in the context of the equity bids process, which is presently underway, having run its course, so that the value of the group on which that permanent restructuring will take place will have been established by concrete market evidence. So, my lord, that's what's happening. Essentially, the plan is relatively limited in scope, in the sense it's making those changes to a bridge to a subsequent plan, which will deal with the permanent restructuring. So, one asks, why is it being said that the plan is unfair? What is unfair in this plan? And in our submission, the case is exiguous. Case put before your lordships on this question of fairness is exiguous. It comes down to, certainly so far as the Class B HG is concerned, the June release condition and the information rights. Now, the short point is the judge considered both of those aspects in considerable detail. It's set out in section L of his judgment. The most you can say about it, by way of criticism, is that section L appears in a section of the judgment dealing with the no worse off test. He was in fact right to deal with it in that context, because at that stage the June release condition was said by the Class BHG be relevant to the no worse off test. And perhaps the sort of highest the criticism of the judge goes is when he came to deal with discretion and fairness, he should have been more explicit about including a cross-reference back. But he dealt with this in detail. So far as the June release condition is concerned, he rejected the case that this might have the effect of diverting value away from the Class B AHG. They haven't appealed that. And he made factual findings about the extension right, which is given to the plan company. Again, not appealed. So far as the information rights are concerned, somewhat surprising, this hasn't, I think, been put before your lordships yet, but the judge considered these, and he in fact settled an amendment to paragraph 59 of Schedule 4 of the Common Terms Agreement at the consequentials hearing. Your lordships may recall from reading the judgment that he raised the question of whether paragraph 59 ought to be amended.
Yeah.
And it was in fact amended. And I'll show your lordships this in due course. So, he in fact, having had submissions on how it ought to be amended, decided on the form of that. And the form which he decided on gives additional information rights to the Class B creditors and the subordinated creditors. So, plainly...
That's set out in paragraph 3 of his ruling on the consequentials.
Exactly right. And we have a red line in the bundle, which I'll take you to in due course, just to show you what the amendments were. But plainly, he considered that, and he came to a view on what he thought was appropriate. And the idea that his conclusions on either the June release condition or the information rights fall outside the ambit, generous ambit given to him as a judge at first instance is, in our submission, fanciful. So far as TWL is concerned, as we understand it, they argue that the terms of the super senior financing, whilst they don't disagree with the concept of it, they say the terms are too rich, it's too expensive. They put on no evidence at all to support that proposition before the judge. The evidence which the court did have is that the terms of the super senior financing are 9.75% in terms of coupon. The evidence of the two experts as to the rate which the government would charge in SAR was 9.5% per Mr. Cowlishaw or 8.87% per Mr. Heiss. There is no evidence at all that these terms are too rich, too expensive. This is just a mantra, pure assertion from TWL. The other point about TWL is you might have thought from their submissions that their complaint is that they've been wrongly excluded from the ability to participate in the super senior financing. As your lordships know, the ability to participate in that financing is open to the Class A creditors and the Class B creditors. It's not open to TWL, but my lord made it very clear to us that they're not willing to provide any further financing to this company. And if I could just take you to the supplemental bundle at divider 32. Page 1084 to their skeleton argument, which they raised before the judge.
Sorry, tab.
So this is tab 32. It's in volume 3 of the supplemental bundle. And it's paragraph 4. principally the last sentence of paragraph 4, which is over the top of the previous page, 1085. Neither is it proposing to inject further sums into the plan company as part of the bridge financing, whether carried out pursuant to the A plan or the B plan. Now, they're our shareholder. They've effectively abandoned the group. They don't want to put more money in. And we say it doesn't lie in their mouth to then come along and implicitly claim about not having the ability to participate in the super senior financing.
But it's this, my lord, we've never said that, and we continue not to say that.
Well, it's implicit in their complaint about the super senior funding that they don't have the ability to participate in this, and they've never asked for that ability, and their position is that they don't want to do that. It is, yeah, it is in their grounds of appeal, but let's deal with that if we need to. So I invite your lordships just to take a step back and ask yourself, well, what is fundamentally really unfair about this plan? Your lordships have heard a lot of submissions about the law, out of the many creditors, valuation and so on. What's unfair about it? What's wrong with this plan? And in our submission, asking that question exposes this appeal for what it is. And it's essentially an attempt to overturn the judge's own evaluation of whether the plan was fair and his decision to exercise his discretion to sanction the plan. And that's essentially what is sought to be done here. And in our submission, for reasons that are fairly obvious, that's not promising ground for an appeal to this court. Now, just on that topic, at the risk of going over ground which your lordships are very familiar with, can I just make two specific points on the approach to appeals before this court? The first is the approach that this court will take to findings of fact by the judge, including the judge's evaluation of the facts. And I suspect your lordships are more than familiar with this, but perhaps I can just show McCarthy and Jones, which is in I think your lordships will have it in Authorities Volume 6, Divider 112A. It's paragraph 18. And these statements of principle actually you find in a number of cases from this court. But you can see in paragraph 18, Lord Justice Lewison, it is, refers to his earlier decisions of this court in Fage and then Volpe and Volpe. Appellate courts have been repeatedly warned by recent cases at the High Court not to interfere with findings of fact by trial judges unless compelled to do so. This applies not only to findings of primary fact, but also to the evaluation of those facts and the emphasis to be drawn from them. And then if you go over to paragraph 19, he set out some other principles. Under Roman numeral 2, what is meant by plainly in this context? So in other words, in assessing whether the judge has gone plainly wrong, what does that mean? And what matters is whether the decision under appeal is one that no reasonable judge could have reached. And then, can I just draw your attention to Roman numeral 3 and also Roman numeral 6?
Yeah.
So Roman numeral 3, an appeal court is bound, unless there's compelling reasons to the contrary, to assume that the trial judge has taken the whole of the evidence into his consideration. The mere fact that a judge does not mention a specific piece of evidence does not mean he overlooked it. And then reason 6 as well, which is, in my estimation, particularly apposite given some of the criticisms which have been made of this judgment. Reasons for judgment will always be capable of having been better expressed. An appeal court should not subject to judgment to narrow textual analysis, nor should it be picked over or construed as though it was a piece of legislation or a contract.
Well, that picks up the point you made a moment ago about, you know, he might have said in the context of fairness, I refer back to what I said earlier in my judgment, like no worse off.
Exactly, and we do accept in a couple of places he could have expressed things better, but fundamentally that criticism is one of critiquing his drafting rather than identifying any substantive way in which he's gone wrong. So that's Jones and McCarthy. The other authority I just wanted to show you as well is another case of this court called Aldi Stores against WSP Group, which is in the authorities at Divider 41, which should be in volume 2 of your Lordship's bundles. We cite this in our skeleton, but it's particularly apposite when it comes to the nature of the judge's discretion, in this case to sanction the plan. It's paragraph 16. And if we just pick it up, I think third sentence in, nonetheless, an appellate court will be reluctant to interfere with the decision of the judge where a decision rests upon balancing such a number of factors. The types of case where a judge has to balance factors are very varied, and the judgment of the courts as the test to be applied are expressed in different terms. However, it's sufficient for the purpose of this appeal to state that an appellate court will be reluctant to interfere with the decision of the judge in the judgment he reached on abuse of process, and that was the particular issue in that case. By the balance of the factors, it will generally only interfere where the judge has taken into account immaterial factors, omitted to take account of material factors, erred in principle, or come to a conclusion that was impermissible or not open to him. Now, in my submission, the judge's exercise of his discretion to sanction a plan essentially involves that sort of exercise. You can see this from his judgment. He's identified the factors, and then ultimately he has to undertake a balancing exercise. Whether
multifactorial assessment.
Yeah, exactly. And we submit that the question of this court revisiting that only arises if it falls within the test identified by this court in Aldi. So ultimately, we say that the threshold for the appellants to surmount on these appeals is a very high one, and broadly, they have to demonstrate that the judge's decision to sanction the plan was not one which a reasonable judge could have reached. And we respectfully submit the appeals don't come close to showing that. Now, that's what I was just going to say about approach. I'll then turn to deal with the substantive grounds that are put forward broadly in the order we deal with them in our skeleton argument. So the first is the question of fairness. And of course, at the outset, emphasise that although we talk of fairness, this is actually an aspect of the judge's discretion to sanction the plan. It's not a jurisdictional point we're concerned with. There isn't any issue now about the no worse off test. The question of fairness is part of his discretionary evaluation of whether he should sanction the plan or not. Now, the judge obviously did decide to exercise his discretion to sanction the plan. He did so including by relying on what's called the cross-class cram-down power in section 901G. And in our submission, in doing so, he applied the correct legal test. He took into account the relevant factors. He attached the weight he thought appropriate to those, and he didn't take into account anything that was irrelevant. Now, in terms of the basic test, the essential test as to how to exercise the discretion to effect cross-class cram-down was explained by the Court of Appeal in Adler. That's the authoritative decision on this point. The key passages Adler were set out by the judge at paragraphs 152 to 155 of his judgment. It might be worth just turning it up so your Lordships have it. It's tab 3 of the court bundle, page 148 of the bundle. And you can see 152 to 154. And then also 155. In fact, he has identified the relevant passages from Adler. Now, the passage which is perhaps most important are the passages at 159 and 160 and 161 from Adler, which he sets out at 153 of the judgment. And what those passages make clear is that where you have a restructuring plan with a dissenting class, the court does need to consider the question of substantive fairness, if I can call it. If you go over to the top of 150, as Lord Justice Snowden said in Adler, and as the judge quotes, in my judgment, that exercise of a judicial discretion to alter the rights of a dissenting class for the perceived benefit of the assenting class is necessarily requires the court to inquire how the value sought to be preserved or generated by the plan over and above the relevant alternatives to be allocated between those different creditor groups. And then as he goes on, it's this concept that's been encapsulated in the expression, the fair distribution of the benefits of the restructuring, or the fair distribution of the restructuring surplus, sea, deep, ocean and house. So he's identified exactly the right point from Adler, which is where you have a plan with a dissenting class. The court does need to consider the question of substantive fairness in considering whether the allocation of benefits under the plan is fair. And he clearly has that well in mind. Now, if we then go on to the judge's analysis, if you go to page 245, so paragraph 245 on page 210, he deals with the question of fairness. And as I said earlier, by this point he has in fact already dealt with what he called the Class A control terms, which are the due and release condition and the information rights. And if you look at 245 to 249, in our submission, the judge in fact makes 5 points. The first, which you get from 248, and also the last sentence of 250, is that he found the Class B creditors were out of the money in the relevant alternative, and little weight was to be attached to their views. Now, just whilst we're on that, you'll notice that in 248 final sentence and 250 final sentence, the term he in fact uses correctly is that little weight is to be attached to their views, or conversely, you don't attach greater weight to their views. And he's approached it in exactly the way Virgin Active suggests, that if you're an out-of-the-money creditor, then it's a question of what weight you attach to their views, their objections, and if they are out of the money, those carry little or no weight. So that's his first point. His second point you get from the first sentence of 249. I'm satisfied that the present case gives rise to no issue of horizontal fairness of the kind explored in Adler. I'll come back to that, that's an important point. Thirdly, also in 249, the plan is an interim restructuring plan which involves no restructuring surplus. Again, we say he was right about that. And then in the same sentence, in fact, there's then the fourth point, which is even if it did have a restructuring surplus, all of the plan creditors are treated equally because the plan creditors are entitled to participate pari passu in the super senior funding. And fifthly, and this is paragraph 250, he held that the basic objection of the Class B AHG to the plan was not the apportionment of the restructuring surplus, but the fact that inserting the super at the top of the debt structure was to push down the Class B debt out of the money. But he said, well, that's always going to be the outcome of an injection of new money where the Part 26A jurisdiction is engaged, and indeed that would be the outcome of the injection of government funding in a SAR. So those are really his composite reasons, and we say that there's 5 reasons you can identify. The second reason, which that this case gives right no issue of horizontal fairness of the kind explored in Adler, isn't appealed. But it's important to understand what the issue was that arose in Adler and why the judge attached weight to the fact that there was no similar issue in our case. The issue that arose in Adler was that the plan in that case didn't provide for the pari passu treatment of creditors as a matter of substantive distribution of the benefits of the restructuring in circumstances where they would have ranked pari passu in the relevant alternative to that plan and where there was no proper justification for deviating from that position under the plan. And so the basics of issue in Adler was that there was a change in the priority rights of creditors relative to each other, which wasn't properly justified. Now, the plan in the present case does not seek to do that. It doesn't depart from the priority of distribution applicable to the plan companies, applicable to the plan creditors as between each other, which would apply in the relevant alternative to the plan, namely a SAR of TWUL.
So that sentence is very important to read the words of the kind explored in Adler, is it?
Yes.
It's not, there's no issue of horizontal fairness. It's not of the kind in Adler.
Yes, no, absolutely, yes. No, exactly. He's making a point here, specifically by reference to the mischief that arose in Adler, and that mischief that arose in Adler was the deviation from the priority that would have applied in the relevant alternative, and that there was no proper justification for that deviation. But the reason why that is an important starting point for assessing fairness in this case is that the plan in this case doesn't seek to depart from the priority of distribution applicable to the plan creditors each other. They remain ranking in exactly the same way, and indeed they remain with the same debt rights subject to the 2-year maturity extension. And all that happens is the new super senior debt comes in, but that would happen in the
That would happen anyway in the SAR.
So there is, he was quite right in our submission to attach weight to that point, because there isn't an Adler type issue and the plan doesn't deviate from the treatment of plan creditors in the relevant alternative. So that's the second point he relied on. Now, on the out of the money point, the judge concluded that because he'd found the Class B creditors were out of the money, and indeed the subordinated creditor as well, little weight attached to their views. Now, in our submission, the judge was right in that approach as a matter of law, but in any case, the point goes nowhere as an independent ground of appeal, because the judge, in any event, considered the issues of fairness. You have the remainder of the 5 reasons I've just identified, and also you have the fact that in section L of the judgment, he had gone through the June release condition and the information rights and found them to be unobjectionable. So as an answer, I don't accept that this point, given the way the judge dealt with the matter in toto in his judgment, I don't accept that this point would vitiate his judgment in any event, even if he'd been wrong as a matter of law. But I submit, actually, he was very clearly right on this point, and the way he approached it.
So you don't suggest that no issue of fairness can arise because the B creditors are out of the money?
No, that's putting it, no, that's putting it, so I think your lordship's got, is your lordship looking at 246 first
Well,
sentence?
but that's where
Yes.
it's recorded, isn't it?
I agree. I mean, that is putting it too high. It's not that no issue of fairness can arise because the B creditors are out of the money. It's that when you're considering the question of fairness, you attach little or no weight to the views or objections of out of the money creditors.
So as the judge puts it too high there. Is that true of the first sentence of 245? Is that how high you put the point?
No, we didn't. Well, the first sentence of 245 is right, because that's the point about it didn't generate a restructuring surplus.
Well, if you add in the words horizontal fairness of the kind explored in Adler, it would be right.
I'm sorry?
Because your submission is no issues of horizontal, issues of fairness arise because it didn't generate a restructuring surplus. I think when you only got to 249, that was in the context of no issues of horizontal fairness of the kind explored in Adler.
Yes, so horizontal fairness in the sense of looking at the allocation of benefits between,
Which you regard as allocation of distributions.
effectively, I mean, that's if you go back to 159 and 160 of Adler, it talks about it in terms of allocation of benefits.
Yes, it was a distributing case.
Yes.
Yeah.
So allocation of benefits. So ultimately, the restructuring surplus point is that if there isn't a restructuring surplus, then the question of allocation of benefits doesn't arise because
Well, the point against you, I think, is that restructuring surplus is a dangerous term.
Yes.
It isn't just about generating a particular piece of value. It's
Yes.
the benefits derived from the plan.
Yes.
Whatever they need, may be financial or non-financial, need to be shared appropriately.
Well, yes. I mean, we're going to come to this point because there is a question of law which, in our submission, has not yet been decided as to what approach the court should take in evaluating the distribution of non-financial benefits, to use that word. Adler, as your lordship rightly said, is looking at distribution of financial or economic benefits. Obviously, every restructuring plan will contain, when you take into account its associated agreements, hundreds, if not thousands, of terms. And there will be things like information rights, hundreds of, if not thousands, of different rights given to creditors as part of the average restructuring plan. Now, our submission is that when you're dealing with non-economic rights of that nature, then the test can't be that you go through each and every one and say, well, actually, that could be improved in some way. That one isn't fair. You could amend it in that way. That gives that person too much. That gives that one too little. We propose a different test for that, and I'm going to come and explain what we say that should be. But even if I was wrong about that, and let's say you do treat these non-economic rights in the same way as Adler, well, there's no unfairness in this case anyway. I mean, the treatment and the way in which those rights are allocated is in any case absolutely fair, and the judge considered it in some detail in section L of his judgment. But so it's perhaps not a point on which this case turns, but it is an important point for restructuring plans generally. I mean, we don't believe it can be right that each and every term of a plan and associated agreements must be subject to an Adler type evaluation, and you ask yourself whether each and every term could be improved or made fairer in some way. So I'll come to that. So on the out of the money point, we say the judge's approach was absolutely right in effectively approaching it on the basis that little or no weight attaches to the views, objections of out of the money creditors. You get that primarily from Virgin Active. If we could go to that, please. It's in Authorities Bundle 4 for your lordships at tab 80. And as your lordships are probably aware, this was the first case involving a contested use of the cross-class cram-down power under Part 26A. So Deep Ocean was the first case that had involved the exercise of the power. It wasn't contested in that case. In Virgin Active, it was. For our purposes, if you go to paragraph 226 of the report, page 114 of the internal pagination, the relevant section of the judgment begins, in fact, with the heading out of the money creditors.
What's the paragraph number?
Sorry, 226, my lord. And then in Deep Ocean, Mr. Justice Trower also considered two related issues that dominated the debate in the incident case, namely the approach to the treatment of creditors who are out of the money and the approach of the distribution of the benefits of the restructuring, what some commentators have called the restructuring surplus. And he deals firstly with the approach that was taken in Deep Ocean. And if you go then to 237, having effectively summarised Deep Ocean, he then deals with the submissions that were made by the opposing landlords in that case. And he says at 237, in addressing these submissions in the instant case, it's first necessary to identify the insolvency process in which considerations of the relative priority between creditors and shareholders would arise. In the instant case, as I found, the comparator or relevant alternative to the plans is a trading administration. So he begins by saying, well, your reference point, if you like, is relevant alternative, and that in that case was an administration in which there would be some trading and then a sale. And then 238, he summarises what has hitherto been the approach of the English courts to this type of situation, and he does so in part by reference to what Mr. Justice Trower had also said in Deep Ocean. As Mr. Justice Trower explained in Deep Ocean, the conventional approach of the English courts to scheme cases under Part 26, in which such a situation has arisen, goes back to Re T Corp, and it can be traced through other cases such as Re Oceanic Steam Navigation and more recent cases such as My Travel and Bluebrook. In each of those cases, the essence of the proposal was that the business and assets of the failed company should be transferred to a new company to be owned by those who would have been entitled to a share in the distribution of the proceeds of sale of those assets in the formal insolvency. By this route, the creditors and shareholders who would be out of the money in the formal insolvency would be left behind in the shell of the old company, and the benefits of future trading would be enjoyed by those who would be in the money in the formal insolvency. So the conventional approach of the English court to this sort of situation where you had out of the money creditors of a company was that it was perfectly permissible to do a restructuring under which you transferred away the assets of the company to a new company, and in the money creditors would be the owners of Newco, and the out of the money creditors and the shareholders would be left behind in Oldco with nothing. And that is essentially how these things used to be done prior to the implementation of Part 26A, and that's the conventional approach described by Mr. Justice Snowden as he then was. And then he cites at paragraph 239 the Bluebrook case, which is one of those cases where that took place. And also you can see within Bluebrook, Mr. Justice Mann referred to the earlier decision in Re My Travel, and then at paragraph 240, Mr. Justice Stone also referred to his own previous decision in a scheme case of Noble Group. Now, just to pick up something from Mr. Phillips's submissions earlier, pausing there, in each of those cases, namely Bluebrook, My Travel and Noble Group, the question of whether creditors were out of the money was assessed by reference to the relevant alternative to the scheme, in which each case was an insolvency proceeding. And let me show you that. Firstly, My Travel at Authorities 1, tab 38, which is in volume 2. So tab 38, volume 2 of your Lordship's Authorities, I think. And it is, you can go straight to paragraph 71, I think, which deals with this point most clearly. As part of the judge's conclusion. So this is page 2396 of the report. So 71, in the circumstances, I accept the conclusions of Miss Mills as being fair and accurate. As a result, it's quite clear to me that the economic interest of the bondholders in the company is nil. There is no serious prospect of their getting anything out of a liquidation. And then if you just pick it up on G, he goes on to say, bearing in mind the very large deficit figures in this case, I can conclude, as Fine Lot J seems to have concluded in the British and Commonwealth case, that the bondholders' prospects of recovery in a liquidation are fanciful or theoretical. But unlike him, I find myself able to conclude that that means that the bondholders have no economic interest in the company. So way it was approached in my travel was the alternative was a liquidation on the evidence. Mr. Justice Man was able to conclude the bondholders wouldn't make any recovery in that liquidation, and therefore they had no economic interest in the company. They therefore didn't need to be party to the scheme that effectively went ahead without their involvement. Bluebrook is in divider 45.
Yeah.
And your lordship should have this in volume 2 again. With me. Now, my little friend Mr. Phipps took you to some of this yesterday. If we go firstly to paragraph 13, which he took you to, now, Mr. Phillips relied on the sentence against letter F, saying the report carried out a valuation of the group on various bases. It's clear that the report valued the group on a going concern basis, not on a liquidation or even a fire sale basis. But you need to look at the first sentence, and you can see that the report was prepared for the administrators. So the premise of all of this was the company would go into administration. Now, the fact that the valuation was carried out on a going concern or liquidation basis is entirely besides the point, because that simply reflects what would happen in the administration. It may be perfectly possible that within an administration you would have a going concern sale, and that would mean a going concern valuation would be appropriate. But it was looked at again by reference to the alternative of a pre-pack administration. And if you get the same point at 36, because if you go on to paragraph 36 against letter H, the evidence in that case, like many of these cases, was that the alternative to the restructuring would be an insolvency proceeding of some kind. So if you look against letter H, where the director is, where Mr. Justice May is summarising the evidence of the directors, a later paragraph was firmer. He expressed the director's view that in the absence of either the present or an alternative restructuring, they will have to petition for some form of insolvency proceedings for most, if not all, the existing group companies in order to protect their assets, because enforcement of security would be likely to occur and the level of performance of the group is such that the current level of debt has become unsustainable. So the relevant alternative in that case was, as in my travel, like also the present case, an insolvency proceeding of the company. And then the third case is Noble Group itself, which is in divider 63, and your lordships will have this in volume 3, and this was Mr. Justice Snowden's own earlier decision. And if you go to,
Sorry, divide. Is it tab?
so it's tab 63,
63, thank you.
and you need to go to page 396 of the report, which is paragraph 79. Of the second judgment, the sanctioned judgment, and you can see from 79, he says, as I indicated in the convening judgment, the holders of the perpetual capital securities were not included in the definition of scheme creditors whose claims are to be compromised by the scheme. The reasons were that it's generally for the company to determine with whom it wishes to propose the compromise arrangement under Part 26, and it was thought by the companies and its advisors that the subordinated claims that the holders of the perpetual capital securities were sufficiently out of the money in the sense that they would manifestly receive no distribution in a liquidation of the company, that they did not need to be consulted on the scheme. So again, it's the question of whether they're in or out of the money is assessed by reference to the alternative, which in that case was a liquidation of the company. So, in my submission, that's the conventional way in which the English courts had looked at this matter prior to the enactment of Part 26. If we go back to Virgin Active, having had that detour, and go to paragraph 242 on page 119, you get in my submission, which is then what is one of the core paragraphs in the judgment, because Mr. Justin then summarises what the established approach is. That established approach in relation to scheme cases reflects the view that where the only alternative to a scheme is a formal insolvency, in which the business and assets of the debtor company would be held on statutory trust for realisation and distribution to creditors, that business and assets in essence belongs to those creditors who would receive a distribution of the formal insolvency. And this is the economic ownership point, that it's the in-the-money creditors who own the business. The authorities take the view that it is for those creditors who are in the money to determine how to divide up any value of potential future benefits which the use of such business and assets might generate following the restructuring surplus. So what he's saying there is that effectively, hitherto, English courts have approached it by looking at this question of whether creditors are in or out of the money. You do that by looking at whether they receive a distribution in the relevant alternative, which may be is likely to be an insolvency proceeding, and it's for the in-the-money creditors to decide how the benefits of the restructuring are distributed. And it's on that basis, under the old procedure, the out-of-the-money creditors may find themselves not being parties of the scheme, but simply left behind in old code. Now, what he then says is essentially he explains why it is that those principles have been traced through into Part 26A. And you get this at 243. These principles were plainly understood when Part 26A was introduced into the Companies Act 2006 in the midst of the pandemic in 2020. And I'm not going to read them all out, but it's worth reading if your lordships have time. 244 and then 246. 244 through to 246, where he looks at some of the explanatory materials. And then 247, against that background, there's nothing in the provisions finally enacted as Part 26A or in the explanatory notes that indicates that the legislature intended a different approach to be adopted by the court to the position of creditors who are out of the money under the relevant alternative. So looking at the position of the relevant alternative, quite the reverse. The provisions of Part 26A build upon that approach. Although Section 901C3 provides that every creditor whose rights are affected by a plan must be permitted to participate in a class meeting, Section 901C4 provides that this does not apply to a class of creditors if the court is satisfied that no member of that class has a genuine economic interest in the company. It is, I consider, tolerably clear that this test of a genuine economic interest reflects the observations of Mr. Justice Mann in Bluebrook, that what the court must ascertain is whether a proposed class actually has an economic in a real as opposed to a theoretical, merely fanciful sense, and that it is to be applied to the plan company by reference to the relevant alternative for the company if the plan is not sanctioned. So effectively what he's saying in our submission entirely correctly is this conventional approach was quite well understood at the time. It informs the approach to Part 26A. In fact, Part 26A takes that same approach even further, because it allows you, right at the outset of proceedings, to apply to disenfranchise creditors entirely who are out of the money. In that way, it goes further. But it's essentially, as he said, building upon the same approach. And then 248, he cites paragraph 188 of the explanatory notes, says that conclusion is, to my mind, put beyond doubt. And because of the express way in which no genuine economic interest is equated with out of the money class. And then you get on to 249, which is the key point, where he essentially pulls the points together. And what he says is essentially two things in that paragraph. In the second sentence, he essentially says the fact that creditors who are out of the money have voted against the plan is something that doesn't shouldn't weigh heavily or at all. So the first point he makes is if
they could have been excluded in the first place because they're out of the money, the fact that they weren't and they participated in the meeting shouldn't
exactly
be given any weight.
exactly.
Much weight.
Exactly. So you can absolutely see his logic here, which makes perfect sense. And then the second point he
It would
made,
be rather surprising if Part 26A, having introduced the cross-class cram-down concept into English law, a different test applied in relation to out-of-the-money creditors there in that situation than applied under the normal scheme
exactly,
cases.
exactly. Not least because Part 26A was designed, at least intended to make things
Designed
easier.
to,
Yeah.
expand the law, not contract it.
Exactly. So he makes the point about the weight you attach to the voting, and he couldn't really be clear about that. And then he also makes the other point in the penultimate final sentences that aside from the voting point, it's not easy to see on what basis they could complain that the plan was unfair or not just and equitable to them. And that was essentially the same point that Mr. Justice Trower had made in Deep Ocean in paragraph 51. Is basically saying, well, if you're out of the money, what is the ground you have for saying that the plan is unfair? If you wouldn't receive anything in the relevant alternative, what basis do you have for coming along and saying this plan treats me unfairly? Because you wouldn't receive anything in the relevant alternative. Well, what's unfair?
Well, it may be because the plan enables those in charge of it to avoid the consequence of a transfer scheme. That may be something they don't want. They actively want a restructuring via a plan process for which they need the not either the consent of or the cram down of the rights of the dissenting creditors. You need to override those rights. So there's something in that, isn't there? Something
No, because I mean that's if you didn't need to. I mean that's the position in every case. I mean otherwise you wouldn't be doing a plan at all. If you didn't need to override someone's rights, you wouldn't have a plan, and you wouldn't have a dissenting class. So in every possible case where this issue would arise, you're necessarily going to be overriding someone's contractual rights. That's the whole reason why you're doing a plan. But if that person in fact has no economic interest because they wouldn't receive a distribution in the relevant alternative, they don't have a basis for coming along to court and saying that's unfair. And in particular, it's unfair because I'm not receiving a benefit under this plan.
They do have a right to something, don't they? Because you have to have give and take with them. Or do you say that's not right?
Well, that's a separate point, we say. I mean, the give and take point is, we'll come to this in the case in relation to Adler. The concept of an arrangement requires you not to be subject to a complete confiscation of your rights. But you have to be given something, but it may be de minimis. It can be absolutely tiny. And that's the approach the cases have adopted. But that isn't related to the distribution of the restructuring surplus. That's satisfying a jurisdictional point on the meaning of arrangement. And the amount you have to give the creditor to satisfy that isn't assessed on fairness grounds or by reference.
How is it assessed?
It's simply said it's got to be more than de minimis. And so the amounts in practice have been absolutely tiny. I mean, if your lordship's interested, we can show you what has actually been paid in the cases in order to satisfy that point. And
Presumably no one's ever contested it.
yes, Mr. Alatot took this point against me in aggregate, in fact. So, but I can forgive him for that. But that's a separate point in my submission, my lord, and we'll come to that because it goes to the question of the ratio in Adler. So 247, I mean, ultimately, we say 247, 249 of Virgin Active are very clear. It's just to deal with another of Mr. Phillips's points. It's clear for the purposes of 901C4 that the question of no genuine economic interest is assessed by reference to the relevant alternative. He tried to make a point to say, well, 901C4 doesn't itself use the words in the relevant alternative, it just stops and says no genuine economic interest. 3 points on that. The first is you can see from the history that the question of no genuine economic interest has always been approached by reference to the relevant alternative. Second, it makes sense to approach the question by reference to the relevant alternative because you're asking yourself, well, what would happen if this plan isn't sanctioned? And it's logical to look at the rights of creditors in the situation that would actually transpire if the plan isn't sanctioned, rather than some hypothetical situation that wouldn't in fact transpire. And thirdly, not only was this Mr. Justice Snowden's view in Virgin Active, it was also Mr. Justice Miles' view in Smile Telecoms, which is the only case that where there has in fact been an order under 901C4. And if you go to tab 100 of the authorities, in volume 5, I'll just show you the passage. So it's paragraph 77A of Smile Telecoms. Mr. Smiles, as I say, this is the only case where there has in fact been a disenfranchisement order made under 901C4. And unsurprisingly, when Mr. Justice Miles was considering the principles, he looked carefully at what Mr. Justice Snowden said in Virgin Active. And you can see at 77A, seems to me that the following conclusions can be drawn from those comments and from the section itself. First, in considering whether a creditor or member or class of creditors or members has a genuine economic interest in the company, the court considers the position by reference to the relevant alternative for the company if the plan is not sanctioned.
Was that a point that was an issue in the case and argued?
I don't know if there's actual argument on that actual point, no. Now, if you go back to Virgin Active again,
I think it's being pointed out to you, Mr. Smith, you were in the case.
I was.
Do you mind? I mean, it's fair to say one doesn't always remember all the cases.
Some of them tend to merge into each other. I have to say.
One might be forgiven if it's only 3 years ago.
Yes, well, anyway. I think the answer to my Lord's point is that I don't think that point was a subject of a contentious argument, but clearly Mr. Justice Miles thought that was the position, having looked at what Mr. Justice Snowden said. Now, if we just go back to Virgin Active again, and I promise this will be the final time, back in Divider 84. We'd got to 249. You also need, in my submission, to look at 266. Because one of the points that's made is to say, well, part of 249 is expressed in quite tentative terms. But if you look at 266, it's interesting to see what Mr. Justice Stone says when he comes back to the analysis. He says, instead, as indicated above, the HG landlords objected to what they see as the favourable treatment given to the shareholders, who will not be required to surrender any of their equity in the group, and will therefore share in the potential restructuring surplus. I have, for the reasons that I've explained, found that since the AHG landlords would be out of the money, their objections to what the secured creditors have agreed with the plan companies in this respect carry no weight. So it couldn't be more unequivocal than that. Now, what he goes on to do in 267 onwards is to identify some reasons why it might have been justified anyway, some additional reasons as to why the treatment of the shareholders was nonetheless justified. But as you can see from the final sentence of 267, all of that is essentially obiter, because he's satisfied he could have got there anyway, simply on the basis that because the HG landlords were out of the money, their views carried no weight. And if you go to 300, on page 131, the end of that section, where he deals with the other reasons why the treatment of the shareholders was justified, you can see he puts it in terms saying, even putting aside the fact that the AHG landlords are out of the money, I therefore do not conclude that the retention of the equity by the shareholders on terms of the restructuring should have led me to exercise my discretion to decline to sanction the plans at the request of the AHG landlords. So the ratio of the decision certainly is that the views of the out of the money landlords carried no weight. Now, Virgin Active has been followed in subsequent cases. We've cited those in paragraph 32 of our skeleton. Those include the Housed decision, which is in volume 5 of your Lordship's bundle at divider 101. And it's paragraph 27 of Housed. Maybe it's 102 actually of, yeah, sorry, 102 of your Lordship's.
102.
Yeah, and it's paragraph 27. And first say, I don't think House was an opposed case in the sense no one turned up to argue, although there was non-consent from one of the parties. But paragraph 27, where creditors or members would receive no payment or have no economic interest in the company in the event of the relevant terms being little regarded to be paid to their views, that was the view taken by Stone J in discounting the fact that classes of out-of-the-money creditors voted against the restructuring. In Virgin Active, that was particularly so because any out-of-the-money class of creditors or members may be excluded from the meeting to consider the plan. That's the 901C4 point. For the same reasons, I consider that little, if any, way is to be given to a vote in favour of the plan by a class or class of out-of-the-money creditors or members. Now, I mean, it's fair to say that's one of a number of cases which we've identified that effectively all say the same thing. And in our submission, effectively, that's what the judge said. In this case, unsurprising because he was referred to essentially all those same cases. Now, in our submission, the relevant parts of Virgin Active were applied and approved by this court in Adler. We disagree with Miss Peters that the Court of Appeal's reasoning on this point was obiter. Adler you have in volume 6 at tab 118. The relevant part of the judgment is at 239, paragraph 239, page 800 of the report. Now, the argument that was put here as one of our grounds of appeal, which we lost on, was that we said that because the economic owners of the company were the in-the-money creditors, then the shareholders shouldn't receive anything. So essentially we said, look, the shareholders are out of the money, therefore they shouldn't get anything. All of the benefits, including the equity in the restructured company, should go to the creditors. And we were effectively arguing the shareholders are treated too well under this plan because they're out of the money. They wouldn't get anything in the alternative of insolvency, but nonetheless they're getting 77.5% of the equity under the plan. And it was put in two ways. The second way is summarised in paragraph 243. Perhaps I can just invite you to cast your eye over 243 because that effectively summarises the point that was being put to the Court of Appeal.
Yeah.
And then if you go to 247, that submission was founded in all material respects, in fact, on what Mr. Justice Snowden had said in Virgin Active, and you can see, because he then sets out at 248 all the way through to 252, the relevant parts of Virgin Active which we've just been looking at in fact, and that reflected that was the foundation of our submission. And then 253, Mr. Smith, Casey, did not contend that my approach in Virgin Active had been wrong. He sought to take it further. And then in 254, again, he effectively summarises the submission.
253, it follows 252, not surprisingly.
Yes.
And in 252, he summarises what he did in Virgin Active and says, I concluded it was for the secured creditors who would be in the money to decide for rational commercial reasons. So he appears there, and he goes on to say the reasons that they gave were justified. But that appears to be an exercise of the horizontal test, doesn't it? As in requiring a difference to be justified, notwithstanding that the other creditors are out of the money.
That's not quite what he actually did. This is slightly sort of conflating, because, I mean, as I showed you in Virgin Active, the way he in fact approached the question at 266 of Virgin Active was to say, the landlords are out of the money, therefore I don't need to have regard to their views. But even if that wasn't the case, here are the following reasons why it would be justified anyway, which includes the point that it's for the in-the-money creditors to decide how value is allocated. And then at 300 of Virgin Active, as I showed you, he then said, even if they hadn't been out of the money, these are the reasons why it would have been justifiable in any event.
My recollection is that your argument was put quite high in terms of what the shareholders should and shouldn't be entitled to get, and I think you have to read what Justice Snowden was saying there really as a response to, I think, what amounted to a submission saying they shouldn't get, the shareholders shouldn't be entitled in these sort of situations to get anything.
That was exactly the submission. I mean, your lordship's...
What you said in 253.
Yes, I mean, that's exactly right. Your lordship's recollection is exactly right. But the basis of that submission was, because applying the analysis of Virgin Active, it's the in-the-money creditors who are the economic owners. They are entitled to the benefits of the restructuring, and therefore the shareholders who are out of the money shouldn't get anything. Now, that was founded on Virgin Active. It was rejected by the Court of Appeal, but it wasn't rejected on the basis that Virgin Active was wrong. If you look at 255 through to 258, Lord Justice Snowden in fact gave 4 reasons for rejecting the argument. The first was a point about whether we'd said that the confiscation of the shares was unfair or not. The second was a point about whether the steerco had acted rationally when negotiating only a 22.5% stake in the share capital. Thirdly, perhaps more substantively, is that Lord Justice Snowden placed reliance on the fact that it wasn't easy to identify a mechanism how the shareholders could have been deprived of their equity, because this was a Luxembourg company, and essentially for those reasons he rejected the submission. But it wasn't because Virgin Active doesn't say what we're saying it says, or that the in-the-money creditors aren't the economic owners. I mean, essentially he rejected it because we couldn't identify a practical way by which the shareholders could have been deprived of their equity. Now, 258, my friend Miss Peters placed a lot of reliance on the provisional view there. That is not suggesting anything that precedes 258 is provisional or arbitrary in any way.
It's just in relation to that 4th point, isn't
Exactly. Exactly right. And the 4th point is the point which my Lord Justice Zacaroli raised earlier, which is whether when you have an arrangement, do you as a matter of jurisdiction have to give something to the creditor or the shareholder, even if they're out of the money, do they have to receive a token? And Mr. Justice, Lord Justice Snow expressed his provisional view that they did, and he came to a different view from a first instance case on that. And that's that point, and I think ever since he's expressed that provisional view, people have proceeded on the basis that that's how it is. But that doesn't mean that anything he said prior to that, or did the Court of Appeal said prior to that, including his recitation of Virgin Active, was obiter. And it's not obiter because this was a ground we lost on. We don't understand that submission. This was a ground of appeal we put forward and which the Court of Appeal decided and which they rejected. And part of the ratio of that rejection was, in my submission, the acceptance of the analysis in Virgin Active. So we do submit that we do submit that Adler is binding authority in this court that those parts of Virgin Active are correct.
Convenient moment to take a break.
It is. Thank you, my lord. It is. Thank you.
Which way do you want to start?
Alex, go musical chairs. Where would you like to sit?
Designed by reference to that.
That one's not, but
Yeah.
Yeah, I'm very nice.
Make reasonable progress. Yeah. Yeah. How many percent am I going
Oh my.
Some ways that's describe.
No, it's
Yeah, well.
no. That's what rearranging is.
Yeah. 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 Right. Okay. We having to do one more?
We're not finished yet. Short break. Not going home yet.
some really good progress there, Tom.
I thought actually, I was reading that clock as well.
Yeah, I didn't wonder when you picked up your laptop.
Could have left.
Job done.
You're up, Sean.
To be honest, I think what important would be to give me a introduction rather than say this, I can help you first. Was it my tragedy?
No, it was.
Precise.
Yes, it was one of the sites. She then lost.
Wow. Perhaps that's the wrong place to choose.
Okay.
Yes, thank you. Very good.
I think I'll have fun. I think you'll get through it.
In which case I can. Or just cut and paste. Sometimes you get a sheet.
No, exactly.
Specific memory that I must. Image in my mind.
Musical chairs, isn't it? I think I've sat here recently. This is good. Just for next to each other. Tomorrow, how exposed they are. Yeah, settle in the old-fashioned way.
Yeah.
Which I think
I'm fine. Yeah, he's not saying much, isn't it?
oh, are you? So I was going to say, that's impressive. Yes.
Court rise.
Thank you, my lord. So just completing then the out of the money point, there was or is reliance placed in the skeleton argument on a decision called Ambatovi of Mr. Justice Hilliard.
Yes.
Nothing's been said about that orally in any submissions from any of the appellants. We've said what we say about it in our skeleton argument. The relevant paragraph, we say this is simply wrong. I wasn't proposing to say anything more about it, given it hasn't been relied on before your lordships in oral argument. I'm happy to do so if your lordships would find it helpful, but I'm conscious of the.
There was no. I mean, it wasn't a contentious hearing of any kind. It was only the judge's observations.
Correct. So perhaps I'll leave and we essentially covered it in our skeleton.
Yeah, you
document.
deal with it.
Anyway. Now, the final point then, just on the out of the money point, is we would just invite the court to step back, and we make the point that the Class B, AHG and TWL don't, in our submission, really supply any reason why, as a matter of principle, a creditor who's out of the money in the relevant alternative should have an entitlement to share in benefits under a plan. What's the substantive reason why it is that someone who wouldn't receive anything in the alternative to the plan should get something under the plan? And indeed, if we were wrong about that, how would you measure what they should get under the plan? I mean, what yardstick would you use to decide what's fair to give an out of the money creditor under the plan if, by definition, they wouldn't get anything in the relevant alternative? And if out of the money creditors should receive something under a plan, does that also apply to out of the money shareholders as well? None of these questions are answered, and there's no reason of principle that's put forward to really sort of justify the underlying point.
Well, I suppose, I mean, the logic of that's extremely powerful if you're talking about money value in that sense, isn't it? Because if you're out of the money, then, as you say, as Justice Snowden, as he said, I mean, why you could be excluded, and why should you have a voice, and more particularly, why should you be given, on what basis you're going to be given anything, even using a criterion of fairness. But it may be that argument doesn't hold up in quite the same way if you're expanding the concept of the value of the scheme to include things that don't have aren't immediately seen as having a monetary value, because those things, you know, I mean, I'm talking now in this case about two creditor rights that are complained of.
But that becomes then incredibly difficult, because I mean, let's take that example and let's assume a case where a creditor is out of the money economically, but they have a contractual right whereby you need their consent in order to do a restructuring. So you've got someone who wouldn't receive anything if the company went into administration, but they have a contractual right, which means they can block you doing a restructure without their consent. So you can say, well, they've got that right. And then you do a restructuring plan. And the purpose of the restructuring plan is to override the need for their consent, because you take the view, well, they're out of the money, they shouldn't be entitled to receive any payment. The whole purpose of a restructuring plan is I can drive this through without needing their consent. Now, on what basis are you then saying, well, that person ought to receive some value? And if so, what value? How do you measure it? And that person wouldn't receive anything in the relevant alternative. You're doing a plan to override the need for their consent. That's the whole reason why you have a restructuring plan in the first place. And it's sort of, I mean, that logic, I fear, would undermine this whole strand of jurisprudence, going back to re T-Corp, because effectively you're then saying, as long as you've got a contractual right of some kind that needs to be compromised under a restructuring plan, then you have to be paid something, even if you're deeply out of the money in the relevant alternative. And with respect, that can't be right. So that's my, I know say that is...
How would you assess what is reasonable for you to receive in those circumstances?
Yeah.
Different people might, as it were, force the issue for different amounts of money.
And also, I mean, the other mischief with that, I mean, that is giving absolute leverage to out of the money creditors, because they're then able to come and effectively say to the company, you need to pay us off. And
well, you do.
Well, not with out-of-the-money creditors.
Well, you do, because it's a minimal amount.
Yes, but it's, I mean, that amount is actually, I mean, I'm very happy to provide your lordship with the.
No, I'm
the schedule. It's
just
tiny
taking
though.
issue with your extreme point that you actually, on the law as it stands at the moment, at least as it's understood, you do have to give them something, although it's only to get over the jurisdiction.
Yes, or unless you go back to doing the old scheme way, which you can still do, where you just leave them behind, in which case you don't need to give them.
Well, so long as you transfer the assets.
Yeah.
Otherwise, and even then, they're left with rights, because they continue to have rights against the old company.
Yeah.
So to the extent that there's any issue that might arise in the future, they could activate. So
Possibly.
there is a benefit to the company in a restructuring and getting rid of that, isn't there?
Yes, but that's the whole reason why that's obviously the reason why the restructuring plan jurisdiction exists. The real question is whether the creditor is entitled to receive a tangible benefit under the plan in return for having that right compromised, and that's the point I would take serious issue with.
Do you say it could? I mean, I can't think of an example. Do you think it's never conceivable that the giving up of that contractual right is such that it has such value that it's worth and generates enough, let's call it a surplus in the restructuring, that it would never be right to compensate the out-of-the-money creditors?
Not if they wouldn't receive anything if you're satisfied that the alternative to the plan is liquidation, where that person would not get anything, then they're not an economic owner of the business and they're not entitled to any share of the benefits created by the plan.
This is a different question, but is there the logic of that the out-of-the-money B-class creditors should have got nothing under this plan?
Yes, I mean, that would have been, that's one of the points I'm going to come to. That would have been justifiable. And in fact, we treat them much better than that in two ways. Yes, because they get paid interest, which gives them the 3.5% in the pound return, and they get the right to participate in the super senior financing. But it would have been perfectly possible to have taken the position that they don't get anything. So that's essentially what we say on the out of the money point. Just going back to the 5 reasons which the judge gave, the second, one of the other points was he said the plan is an interim restructuring plan which involves no restructuring surplus. So this is, if you like, the other side of the coin. He's looking at what the value is, if any, that's created by the plan itself. And in our submission, he was right to say it's an interim restructuring plan which involves no restructuring surplus. Going back to Adler at 118 of Authorities Volume 6, so if you go to the final sentence of paragraph 160 and then the first sentence of 161, the restructuring surplus is the value sought to be preserved or generated by the restructuring plan over and above the relevant alternative. And as Lord Justice said in 161, it's this concept that has been captured in the expression, the fair distribution of the benefits of the restructuring or fair distribution of the restructuring surplus. So essentially what you're looking at is what value does the plan create or preserve over the position in the relevant alternative, which will probably be an insolvency of some kind. And then the question is, how is that restructuring surplus distributed between the creditors? And that's relevant because the question of the fair distribution of benefits is focused on the distribution of that surplus.
Mm-hmm.
Now, the present plan in our submission doesn't generate itself a restructuring surplus or itself provide for the distribution of any such surplus to creditors. And there's 3 points we'd make in that respect. First point is the plan is by design an interim plan. It's explicitly designed to be a bridge to RP2. And it will essentially do that by providing additional liquidity to the group. Firstly, by extending the maturity date. Second, by providing the new money with priority over its existing debt. The plan itself is not a substantive restructuring of the debt or equity. It's essentially a liquidity measure to get the company in a position where it can do RP2. Secondly, the survival of the group as a going concern is dependent on RP2. The present plan facilitates RP2. It effectively allows us to go on the journey to get to a position where we can do RP2. But it's RP2 which will generate the surplus over the position in the relevant alternative of an insolvency. And you can test the matter this way. If the present plan proceeds, but RP2 then fails, which we don't think at all likely, but let's assume for the sake of argument that did happen, then we don't see that there would be a restructuring surplus. So the value which will be preserved or created is dependent on the restructuring in the case of RP2. And then thirdly, the distribution of the benefits of the restructuring will take place under RP2. It's RP2 that will restructure the debt of the group. That will inevitably involve a reduction in the indebtedness, because as my Lord Justice Zacaroli put to my Lord friend Mr. Day earlier, you have a situation where the group is over indebted, both on the basis that its debt stack exceeds its enterprise value, but also its debt stack exceeds what its income stream is able to service. And that reduction in indebtedness will take place as part of RP2, and it will take place, as I said, in light of the equity bids process, which will have established the market value of the group. So it's RP2 which confers rights to the restructured debts on the plan creditors. So in our submission, that the judge's finding that the present plan itself involves no restructuring surplus was right. It can't be said it was wrong, let alone plainly wrong. And as I say, just taking a step back, as a matter of just overall fairness, it is very relevant to have in mind that this plan ultimately is doing something relatively limited. Substantively, changes to the rights of the creditor will take place in RP2, and that will be against the background of marketing exercise, and people will have put forward whatever bids they think the group is worth. So in our submission, the judge was right about that. Now, there's then the question, we then come to the next question, which is the question I touched on earlier about the non-economic benefits related to the plan. And these are what have been described as the June release condition and the information rights. Now, the right to participate in the super senior financing itself is shared between the Class A and the Class B creditors, pro rata to their existing debts. And as I said a moment ago, that's favourable to the Class B creditors, in fact. There's no discount to reflect their more junior status, and in fact, the position could have been taken that they shouldn't have any right to participate at all, given they're out of the money. But nonetheless, they are given a pro rata right alongside the Class A creditors to participate in the super senior financing. Now, as we understand it, the essence of the point which is put against us is to say that it's unfair that Class A creditors who do not participate in the super senior financing should receive the benefit of these rights. So as we understand it, it's essentially said there are Class A creditors who are in effect getting a free ride because they get the benefit of these rights, but they haven't participated in the super senior financing. Now, if I can just begin by putting that point in context, the present position is that 93.29% of the Class A creditors have elected to participate in the super senior financing, and 24.87% of the Class B creditors have elected to participate in the super senior
By
financing.
value, I assume.
Yes, by value. So just focusing on the Class A creditors, the subset, which this point is said to relate to, is very small indeed. It's around 6% of the Class A creditors. The vast majority have elected to participate. And indeed, on the Class B creditors, Mr. Phillips' client has elected to participate. Kington, they've decided to come in and participate in the super senior financing. Now, so just as an outset, this point, in the sense it's a point at all, actually affects a quite tiny proportion. It's effectively saying those 6% of Class A creditors who haven't elected to participate in super senior financing are getting a free ride. That is essentially the point, as we understand it. Now, having given that context, and as I indicated earlier, there's a question about what approach the court should adopt to what we would describe as ancillary rights in a plan such as these. So in other words, rights that don't themselves confer payment or a similar right to a distribution, but in fact otherwise form part of the package of rights given to creditors under the plan. And as you will appreciate, obviously in any plan, there's going to be a huge number of rights, because typically these plans will restate the finance documents, and the finance documents will themselves confer endless rights on the creditors, information rights, benefits of covenants, rights to call events of default, or everything you can sort of think of that would appear in a conventional finance document. So at the outset, there's a question of what approach the court should take in evaluating those, what we would describe as ancillary rights. They don't themselves involve the distribution of economic benefits under the plan. Now, in our submission, we would make 3 points about this. The first is the Adler approach, at paragraphs 159 to 160, is focused on the question of the allocation of the benefits under the plan. And in my submission, what that means is the economic benefits of the plan. So in other words, the key terms which confer economic rights on the plan creditors. What it doesn't require the court to do in my submission is to consider whether each and every term of a plan and the associated agreements is fair or could be improved in some way. And the reason why it can't mean that is that would be an impossible task, because otherwise you'd be faced with a situation of going through each and every right in a plan and saying, well, could you put that right in a better or fairer way? Could that right be improved? What about if you change that right? Would that give something to that creditor they don't otherwise get? Obviously, that would just become an absolutely impossible task. And the second point, we therefore suggest that the judge was right at paragraph 254 of the judgment to accept this submission in the qualified way in which he did. He said, I accept that up to a point. Thirdly, in terms of the test which the court should apply, in relation to terms of a plan and associated agreements which don't themselves involve the allocation of economic benefits under the plan, then we submit that the question for the court should simply be whether the term is a blot. And if it isn't, simply whether there is otherwise an objectively reasonable basis for its inclusion within the plan. But what the court can't do in relation to these terms, we suggest, is go through and say, in relation to each and every term, would it be possible to have a better or fairer plan in respect of that right? Would it be possible to have a better or fairer plan in respect of that right? You can do that exercise in relation to the key economic terms of the plan. You can say, well, look, would it be possible to have a different distribution of the equity, or should the debt be distributed in a different way? Once you descend to the level of looking at these sort of rights, that just becomes impossible.
Would that be true of a right, for example, to appoint a director to the board? That's sometimes been considered, at least in the past, to create class issues.
Yes. So you mean a right given to a specific lender?
Yes, or a creditor. Yeah.
Well, I mean, I guess the question is whether there's an objectively reasonable basis for that, and which there may or may not be. But I mean, if you take the example,
You're in the debate then, aren't you?
yes,
Yeah.
yeah.
So there are non-financial rights which do require justification. Well, there may be. But if you just, I mean, if you look at the sort of rights we're concerned with in this case, so you've got, I mean, let's take sort of information rights, for example, which is a good example because that's one of the examples in this very case. Now, as you know, every facility agreement will have within it information covenants and information rights given to lenders. Now, in relation to any plan, it would be perfectly possible to look at those information rights and say, well, no, I mean, shouldn't the information be quarterly rather than monthly? Shouldn't we get this document rather than that one? And couldn't we amend this so that we got information from some other source rather than from that source? I mean, that exercise you could very easily do and essentially ask yourself, well, could the plan be made, quotes, better by changing the information rights? In my submission, that can't possibly be the approach that Adler had in mind, and there must be a line which is to be drawn, and we submit that the line is to be drawn between those rights that confer economic benefits on the creditors and those rights that are classed as ancillary. So ultimately, we submit you can't in fact apply the Adler test to each and every right that appears in the plan. And so far as the JRC and the information rights are concerned, we submit there is an objectively reasonable basis for their conclusion and they're not a blot. Now, if we're wrong about that, and actually the correct analysis is you just apply the Adler test and ask yourself whether they fall within the fair allocation test and you apply the better or fair plan test, we say we meet that as well because these are fair within that rubric also. Now, in that regard, the first point we would make is that the focus on Class A creditors who've just participated in the super senior financing versus those who haven't is misconceived. And that's because it's all Class A creditors, not merely those who participate in the super senior financing who contribute to the plan and the interim platform transaction. And the non-participating Class A creditors, in other words, the approximate 6%, contribute because they effectively are agreeing to the extension of maturity on £2.9 billion of existing debt. And as part of the interim platform transaction, they were agreeing to the release of the 400 million of trapped cash. So it's not correct that the Class A creditors who don't participate in the super senior financing make no contribution to the plan. That's not right as a premise for this point in the first place. Secondly, the judge, in any case, gave very detailed consideration to the June release condition, and there's no basis for considering that his assessment was wrong, still less outside the range of conclusions which were reasonably open to him. Now, if we just go to the judgment, the June release condition is helpfully set out at paragraph 100, which is 118 of the judgment. And as you can see from the top of 119, essentially it's a condition precedent as to the availability of funding after the 30th of June 2025. You page or paragraph?
So it's paragraph 100, page 119, so right at the top of 119.
Oh, yeah.
And as I say, what it basically is, it's a condition to draw down, in effect, a condition precedent to draw down after the 30th of June 2025. And what it requires is that what is referred to as a supported LUA must have been entered into. And the judge has helpfully set that out in paragraph 100. And you can see what that requires, and essentially there's the two limbs to it. So 66 2/3% of those who've contributed to super senior funding, and 66 2/3% of the Class A creditors. So that's your super senior, sorry, that's the supported LUA. Now, as a starting point, in our submission, it's perfectly reasonable for lenders of finance to a company which is in distress and in need of restructuring to make the drawdown of future parts of that lending conditional on progress with the restructuring. If you're lending into a company that is in trouble, it needs to do a restructuring, it's not unreasonable to say, here's the initial funding, but subsequent drawdowns are subject to either conditions or milestones being satisfied in relation to that funding. So it's not, with respect to a clause that is in any way unreasonable, objectionable, or even odd. Now, the other point is that in any case, there is an obligation on the relevant lenders to extend the June release condition, and this is clause 4.7 of the super senior intercreditor agreement. And if you go over to page 121 of the judgment, paragraph 104, this deals with the entitlement, in fact, of the plan company to obtain an extension of the June release condition. And if you just pick it up about halfway through, you can see it says the majority SSIS creditors shall, so it's mandatory, shall, in connection with a basic consent request relating to the extension of the date for entering into a supported LUA in respect to the June release condition, one, not unreasonably withhold, delay, or make subject to conditions such as extension request, and to consider any such extension request in good faith. Now, so there is a mandatory right to get an extension of this, provided that the parent is acting in good faith towards a recapitalisation transaction. Now, the judge made factual findings about this in paragraph 210 of the judgment, at page 185. And specifically at 186. Subparagraph 3, clause 4.7 of the super senior ICA contains a qualified obligation to consent to an extension of the condition. It's sufficient for the plan company to demonstrate it's negotiating a recapitalisation transaction in good faith. And if it's able to do so, the majority SSIS creditors may not unreasonably withhold or delay consent to an extension or make it subject to unreasonable conditions. And 4, I was initially concerned that this qualified obligation might be difficult to enforce, but Mr. Alatar submitted that the court could enforce it effectively. On reflection, I agree. The plan company has to demonstrate that it is acting in good faith, which is a relatively low threshold. And then once this is established as a subjective question, whether the majority SSIS creditors themselves considering requesting good faith, and an objective question whether they're acting unreasonably. And then essentially, he says they would be acting unreasonably if they tried to withhold consent simply on the basis they didn't like the terms of RP2. And then 5, second sentence, in my judgment, the majority SSIS creditors could not refuse an extension if the plan company was still in the process of negotiating terms, and even if the Class A creditors were unhappy with the price or other terms which are the subject of the negotiation. and then,
Can I just ask how this works in practice? So you get
Yes.
to the 30th of June,
yes,
a sum under the SSF is due on the 12th of July, for example.
yes,
So unless by the 30th of June you've satisfied the JRC, that sum won't be paid.
unless the extension
So-
request has gone in, yes.
So if the extension works, if the company requests an extension,
Yes.
and it's got to be given unless reasonably not,
Yes,
that means that when the 12th of July comes, the sum is drawn down.
well, yes, so they have an obligation to agree to the extension request.
And if you
So
go-
what the company would have to say, we are acting in good faith towards a recapitalisation transaction, because that's that's, if you like, the box you need to tick to get into the extension provision. I mean, I think one is assuming the company would be able to tick that box. As the judge says, it's a relatively low threshold, and then there's the obligation to effectively agree the extension.
So the extension removes pro tanto the condition.
Yes, exactly. So, and then, so that is obviously very important because as to how this provision would operate in practice. That's what the judge says in 210. If you go to 232, he also made a finding here. First sentence of 232, because one of the things that was said was, oh, well, this June release condition is somehow having an adverse effect on the equity process. And he rejected that. And we don't need to turn it up, but his rejection of that was supported by the Rothschild letter, which we have it in the bundle, but I don't think you necessarily need to turn it up given the judge's findings, but Rothschild said there was no evidence that the June release condition had any effect on the equity process, save, I think, for one bidder, Cavalis, who are connected with the Class B AHG. So, the judge has looked at it and has essentially, taking it in the round, has come to the conclusion it's reasonable. The other point which the judge made as well in our submission also has force. If you go back to 208, he really made two important points in 208. The first point is in the second sentence, and what he said was, well, look, what rights to the Class A creditors have anyway, leaving aside what's provided for by this right under the plan, what rights do they have anyway? And he identified quite rightly that they have very significant rights. And he deals with those. I mean, I don't think we need to go through them. But if you go to paragraph 200 and go through to 208, in those paragraphs he identifies all of the existing rights which the Class A creditors in any event have under the finance documents. So, for example, one of the rights, 203, the presentation of a claim form in relation to RP2 would prima facie be an event of default. So you therefore need the consent of the Class A creditors in any case to proceed with RP2. 206 and 208. So 206, separate point but very important. Even if this condition wasn't there, the plan company would try to negotiate a lock-up agreement. I mean, it would do that in any event. The Class A creditors are its principal in the money creditors who hold £16 billion of debt. They would do that anyway. So that's the point he makes in 206 and also in the last part of 208. It's accepted that the plan company would attempt to lock up as many creditors as possible under any of the three plans, and whether or not the IBLA contained the June release condition. So, I mean, essentially, he's also done the exercise of looking at the right in context, of saying, well, what actually does this really add to the rights which the Class A creditor would have anyway, and what does it add to what the company would be doing anyway in trying to do achieve a lock-up agreement with its Class A creditors? And he's taken all that into account as well in our submission perfectly correctly. So ultimately, on the June release condition, there is this question about what test you apply. Do you apply the objectively reasonable test we suggest, or do you fit it within the Adler framework of allocation of benefits? Either way, this is perfectly reasonable condition, and it's a fair condition, and it doesn't represent an unreasonable allocation of benefits between the creditors. So that's the June release condition. Then the information rights. I mean, in a sense, it's slightly odd that this point is still being pursued for reasons I'll come to in a moment. The information rights are set out in the first instance in paragraphs 59 and 60 of the Common Terms Agreement, which is in the third supplemental bundle at divider 50. And the relevant provisions are paragraphs 59 and 60 at pages 1308 and 1309. And you can see that there's two elements to it. Paragraph 59 is concerned with a recapitalisation transaction and what has to happen in those circumstances. And then paragraph 60 is dealing with engagement with creditors. Now, the judge gave very careful consideration to these provisions in his judgment at paragraphs 241 and 243. And paragraph 59 was in fact amended following the handing down of his judgment and prior to the sanction of the plan. If you go to tab 42 of the same supplemental volume, you hopefully have a red line, or at least a document that shows text in black and text in red.
42.
Yes, so it's tab 42. Now, the text in black is the original text that had been included in the version of the Common Terms Agreement which the company was putting forward as part of the plan. The text in red are amendments which were made and settled by the judge at the consequentials hearing following receipt of his draft judgment. Now, what happened was, you may recall that in the judgment he raised the question of whether paragraph 59 should be amended. We then put forward a proposed amendment, and that is essentially reflected in terms of the red text. That was agreed by TWL, and the Class B AHG put forward some submissions to the contrary, and the judge considered the two sets of submissions, and he elected to decide that paragraph 59 should take this form. And if you just look in particular at D over the page, one of the things that is included is that TWUL, so my client, shall provide periodic updates on a monthly basis to the advisors to the secured creditors and the subordinated creditors including, without limitation, amongst others, the Class B ad hoc committee advisors. And then subject to confidentiality arrangements being in place as to the progress of such recapitalisation transaction, and then that's subject to the carve-out that it shouldn't shouldn't require disclosure of information that would in effect prejudice the equity process or breach the MAR regulation. So we do slightly struggle to understand this point because the judge plainly considered it, he identified the point. He himself settled an amendment to the terms of paragraph 59.
I mean, he says in paragraph 4 of his ruling,
Yes,
page 246 of the core bundle,
yes,
Mr Thornton has confirmed this morning on behalf of TWL that this amendment to the plan, that's D, the one we've just been looking at,
yes,
is acceptable. Mr
Yes.
Phillips, on behalf of the Class B AHD, has only just had an opportunity to consider it, asked for time to take instructions if possible for an amendment.
That's
Did Mr
right.
Phillips ever suggest anything else?
He did. So that's what happened was, so TWL agreed it. So Mr Phillips at first didn't agree it. And what happened was competing submissions went in from us and from them, written submissions.
Yeah.
We can provide you with copies if you wanted. And then the judge dealt with it on the papers. He read both sets of submissions and then decided the form of the clause he was going to settle. But my overriding point on this is, I mean, he's plainly considered the point. I mean, he couldn't have considered it more fully or in a more obvious way. He's applied his mind to it. He's thought, well, what's reasonable here? And I'm going to settle the clause in these terms. And there just isn't a suggestion. And it's not even possible to conceive what the suggestion might be as to why that is out of the range of views which a reasonable judge could come to. So that point doesn't go anywhere. I mean, for that reason alone. I mean, there are some other points just one can make in relation to this as well. If you just go back to perhaps the red line, which is in supplemental volume 3 at tab 42, page 1247. One of the things to note when you come to paragraph, I'm sorry, I need to take you, I do apologise, I need to take you actually to tab 50, to the text of paragraph 60, which is divider 50, page 1309.
Yeah, we've got them on the screen.
Yes. So one of the point that's made against us in relation to these rights generally is the Class A creditors who don't participate in the super senior financing are getting a free ride. That's basically what's said. Well, they're not contributing anything, but nonetheless they get the benefit of these rights. That's not right in relation to paragraph 60, because as you can see from the opening words, the information rights aren't in fact given to the Class A creditors. They're given to the relevant creditor advisors and the ad hoc hedge advisors. So they're essentially given to the two ad hoc groups representing the in-the-money creditors who have engaged and assisted with the negotiation of this plan. So it's simply not the case that Class A creditors as a whole, including non-participating Class A creditors, get the benefit of the information rights. They're actually much more focused than that.
But their advisors get it.
Yeah, but these are not people who don't participate in the super senior money.
So what's the definition of relevant creditor advisors?
So that's essentially the Class A AHD. If you go back to 1298,
Wouldn't those creditor advisors have to share with the whole of Class A, whatever?
yes, I don't think I'm being very clear about the point I was making. The complaint that's put against us is that Class A creditors who don't participate in the super senior financing get a free ride by getting the benefits of rights that they haven't contributed for. In fact, paragraph 60 doesn't give rights to Class A creditors who don't participate in the super senior financing. It gives a right to the Class A AHG and their underlying principles But those are the creditors who've engaged, and virtually all of them, I think with some very limited exceptions, are participating in the super senior financing. So this isn't a right that's given to all of the Class A creditors, including people who aren't participating at all. So the basic premise of it is wrong. But in any case, the plan company's position, which the judge accepted in the judgment, was that they would keep all the plan creditors informed throughout the restructuring process anyway. If you go back to the judgment at 242, Core 1, 206.
So
So this is paragraph 242. So this is, if you like, an additional point to the amendment to paragraph 59, third sentence of 242. Mr. Fraser, who's the General Counsel, his evidence was that it was the plan company's intention to communicate with all of the plan creditors throughout the restructuring plan process. I accept Mr. Fraser's evidence, and that is our position. And then I think just the final point was, a specific point was raised in relation to paragraph 60D of Schedule 4. And this is the credit bid point. So this is page 1310. There's a specific complaint made, I think, that paragraph 60D, which refers to facilitating the development of a creditor-led recapitalisation transaction, doesn't apply to the B creditors. Well, the answer to that is that, certainly from our perspective, we don't understand how the B creditors would be able to mount a credit bid in the opposition, in the face of opposition from the A creditors. The A creditors hold £16 billion of senior debt in the company, which is in the money. The B creditors hold £1 billion of debt, which, if the judge is right on valuation, is out of the money.
This isn't about credit bids, is it? It's about creditor-led transactions. The point made, I think, was that they can lead a transaction with others as well. It doesn't have to be a credit bid. But if they did that, and in the context of a proposed restructuring number 2, and the company didn't share information with them, you'd be in serious trouble, wouldn't you, at a convening hearing or even a sanction hearing?
So this is a situation where they come along with a third-party bidder?
Yeah.
Yes, I mean, absolutely. I mean, that process, in any event, will presumably get. I mean, if there's a third-party bidder, that's going to come out as part of the equity bids process, I assume. I mean, if the Class Bs want to put in a bid with a third party into the equity bid process, then of course there's nothing stopping them doing that, and they'd be entitled to exactly the same information everyone else is as part of that process. But the reason this is specifically dealing with a creditor-led transaction, and the reason it relates to the Class A's is because they're the in-the-money creditors who hold the 16 billion of in-the-money debt. But your Lordship's absolutely right. I mean, there's no reason why they would be excluded if they want to come in with someone else through, well, principally through the equity process, one would imagine. So ultimately, we submit there's no unfairness in the information rights, and there's no basis for saying that the judge's assessment was plainly wrong or outside the range of assessment that was reasonably open to him in our submission for those reasons. Now I'm going to that deals with fairness. I'm going to turn to valuation.
Yes.
Now, in our respectful submission, this part of the appeal is very difficult indeed for the appellants. The valuation issues give rise to no issue of law. I think my little friend Mr. Singer accepted this. They're questions of fact and evidence. The judge considered all of the valuation evidence, and he heard the two experts, Mr. Wera-Singer and Dr. Grunwald, being cross-examined. And the judge dealt with the points carefully in his judgment. There's no basis for saying that his conclusions were plainly wrong, or that they're ones which no reasonable judge could have reached. And ultimately, the appeal is simply an attempt to re-argue certain of the points in substance. Now, before I deal with the detail of the points, I just want to say something about the approach which the appellants are now taking to valuation on this appeal. In his submissions yesterday, my own friend Mr. Singler made clear that they're not suggesting that the judge erred because he should have accepted Dr. Grunwald's valuation. In fact, he expressly disavowed any such case at page 124 of the transcript yesterday. He said, "So what I'm not trying to persuade your lordships in this appeal, I'm not suggesting that your lordships say that Dr. Grunwald's valuations were correct. But what we are submitting is that the judge made various errors, which I'll come on to explain. And if the judge had taken into account the point which we say he failed to take into account, that would put the B's in the money." Now, that's very significant, because what the Class B is saying is not that the judge erred because he should have accepted Dr. Grunwald's valuation. As we understand, they're saying he should have accepted Mr. Wera-Singh's valuation, but he should have made certain amendments to it. Put another way, he should have accepted Mr. Wera-Singh's valuation, but only in a modified form. Now that is very significant, and in my submission, there's two serious problems with that as an approach. The first is that that's not the case which they in fact advanced to the judge. Their case before the judge was that Dr. Grunwald's valuation was the correct one, and he should accept Dr. Grunwald's valuation. Tellingly, they've now stepped away from that, and they're effectively saying, well, actually what the judge should have done is taken Mr. Wera-Singh as a base, if you like, but made certain changes to that in their favour, which would have led to a different output on Mr. Wera-Singh's valuation. So that's not the...
That was an alternative case?
No. No. So Dr. Grunwald had different alternative cases within her own valuation, but this case that the judge should have accepted Mr. Wera-Singh, but subject to variation or modification, was never run. It's a new.
It's not entirely fair, my lord, because obviously those points were put to Mr. Wera-Singh in cross-examination. So it was always clear that we were saying, on any view, Mr. Wera-Singh had to take account of the points that I referred to yesterday.
But those points were put on the basis that those were reasons why the judge shouldn't accept Mr. Wera-Singh's valuation. What was effectively said was, well, look, his valuation is flawed for these reasons, and your lordship should go with Dr. Grunwald's valuation. And they've now stepped away from that, and in my submission, it's not an argument they put to the judge. But secondly, in our submission, it's misconceived as an approach, full stop. Valuation is a holistic exercise, and the various elements within a valuation interrelate with each other. And ultimately, what a valuer has to do is take a step back at the end of the day and ask himself or herself whether the valuation is right and whether it's something they're prepared to put their professional name behind. That's ultimately what the valuation is concerned with. It's not satisfactory as an approach to take a valuation of an expert and then make particular adjustments to bits within it in order to increase the overall valuation. I mean, it's very easy to take a DCF valuation and just look at bits and say, well, look, if I increase this input within the WACC calculation from X to Y, that produces a different output. But that's not what the expert is doing. He's using the DCF valuation as a tool, but ultimately to produce a value which, in his or her professional opinion, reflects their view of the value of the company. And if you can just think of it this way, I mean, it's very easy. It would be very easy in practice if a dissenting creditor is faced with a planned company who's put forward a valuation not to put forward their own valuation, but just make arguments on the plan company's valuation, say, well, we see your valuation, but if you change that input, that has this effect, and if you change that input, it has that effect. You could very easily do that as an approach and produce quite big changes in the output, probably.
Would that be wrong?
Yes, because ultimately, what the core, well, firstly, these points interrelate to each other, so you don't know by changing that input whether it has some effects somewhere else. But ultimately, it's holistic, and the expert at the end of the day has to be satisfied that the value that comes out is one that he or she is willing to put their name behind as representing, in their professional opinion, the value.
But
Now,
is the valuation any different from the sum of its parts? It's not. I mean, if you're looking at a DCF valuation and looking at market information as a cross-check and such, then I can see that. But if all you've got is a ground-up valuation using component parts, if you go wrong in the component parts, then you can say, can't you, that the outcome is flawed?
yes, you could say that. Yes, you could say that. But what my point is different. What you can't do, in my speech, is just come along and say not that the output's flawed, but your input within the WACC is too low. So I'm going to change that input, and hey presto, that produces a different figure, and that then is the correct figure. You're perfectly entitled to come along and say the whole thing's flawed. Actually, it's sort of riddled with errors. Doesn't make any sense. It should be rejected. But what, in my submission, is not an appropriate approach is to come along and effectively start within the valuation changing particular inputs to produce different outputs.
But if you get if you put a particular point to the witness, Mr. Weir in this example, and he accepts that there's an error in his approach, then that's one thing.
Yes.
Because then you can say, well, his valuation has to be amended or varied or
Yes.
whatever. But if you put it to him and he doesn't accept it, and the judge then accepts his evidence, what you can't do is then come along and sort of try and tweak his figures. I mean, is that the point you're trying to make?
Exactly that. Exactly that. And can I just give you a practical example of this actually arising on Mr. Singler's own submissions? Because what he did was sort of identify a number of different points. I think there may have been 4, which he sort of tried to ascribe a value to each. And then he sort of said, well, if you top them up and add them to Mr. Weir-Singh's valuation, that means we're in the money.
Yeah.
But just to give you an example, one of the suggestions he made was that 750 million be adjusted for the aggregate sharing mechanism. And that's Mr. Weir-Singh would put a sensitivity analysis on that, and he said, well, let's add that to the valuation. The difficulty with that is that one of his other points was that the TOTEX figures should be reduced to the levels in the final determination. Now, if you reduce the TOTEX figures to those in the final determination, there is no claim under the aggregate sharing mechanism ever, because there is no overspend. So these points, you can't sort of take them in isolation and add them up. If you accept the TOTEX figure, then the ASM becomes irrelevant. So this whole exercise of saying, well, look, here's a particular change, here's another change, here's another change, that change results in X, that results in Y, that results in Z, let's add them up, doesn't work in our submission. And that's just one example. But I mean, you might think it's a bit like a sort of game of whack-a-mole, but you know, there is some truth to this, where you adjust one input somewhere, and you have to ultimately, the expert has to look at it holistically, produce a valuation. So this is what I think this company is worth. So I mean, we don't accept that is sort of valid as an approach for that reason. I mean, there's perhaps just one point I can sort of conveniently deal with now before we break. One of the things my friend Mr. Singler then said was really a sort of precursor to trying to get into attacking the judge's judgment, to say he'd misunderstood the regulatory regime. And he pointed to 2 examples of this, paragraph 177 of the judgment and then paragraph 184. So paragraph 177 is at divider 3 of the core bundle, page 171. So he alighted on the penultimate sentence where the judge said, by contrast, Dr. Grunwald adopted the same rate as Ofwat had used in producing its RCV. Now, except the judge made an error there. It's an absolutely tiny error. What the judge should have said is, by contrast, Dr. Grunwald adopted the same rate as Ofwat had used in producing its allowed return on the RCV. So he made a slip in the sense that the WACC is used by Ofwat not to calculate the RCV per se, but the allowed return on the RCV. It's a tiny point. I mean, absolutely minuscule. I mean, quite frankly, it's not a point we noticed on reading the draft judgment. If it was, it's the sort of point we might have suggested was a sort of a typographical correction. It's minuscule, but also you can't identify any causative effect of that in terms of being productive of an error in the judgment. So, I mean, there's a slight sort of feeling of sort of scraping the barrel here from my little friend, just sort of looking through this judgment with a fine tooth comb to find things they can criticise. The other one was 184, second sentence. And my little friend, Mr. Singler, also criticised this. We, for our part, think it's Mr. Singler who has made an error here rather than the judge. The bit that was criticised was even inconsistent with the assumptions used by Ofwat to calculate the RCV. Now, the assumptions that the judge is referring to here is the inflation rate assumption of about 2%, which is used by Ofwat. In fact, the judge is right that inflation rate assumption is used by Ofwat to calculate the RCV. And if I can just show you, if we can go to Sup 2/15/523.
Supplementary 2.
So this is supplemental volume 2, divided 15/523. And this is in Dr. Grunwald's report. And in paragraph 2.11, she's discussing the Ofwat price review process. But as you can see from the first sentence of 2.11, one of the things Ofwat does is adjust the RCV itself according to inflation. So in fact, the judge was right to say that the inflation assumption is used by Ofwat to calculate the RCV. It's used to increase the RCV in line with indexation. So, and that's not only a tiny point, but it's wrong. Well, that might be a convenient moment. I'm going to move on to dealing with the constituent element. We've actually made reasonably good progress. So
Sorry.
we've made reasonably good progress.
Okay. Well, 10 o'clock tomorrow morning.
All rise.